Recently, a lot of attention has been paid to a public records lawsuit filed in Duval County, Florida. The case, Jeffrey Marcus Gray versus Lutheran Social Services of Northeast Florida, Inc., has been discussed on the front page of the Florida Bar magazine, in newspaper articles statewide, and was even given more than a passing reference in another public records case before the Florida Supreme Court. The final order, issued by Circuit Judge Jack Schimmer, is problematic for a number of reasons, which I'll discuss in a moment. But first, here are the basic underlying facts of the case. In May of 2014, Gray visited the offices of Lutheran Social Services, LSS, in Jacksonville, Florida. LSS has a contract with the Florida Department of Children and Families to provide various social services to vulnerable populations. The contract explicitly makes LSS subject to Florida's exceedingly broad Public Records Act, a fact that was not in dispute during the litigation and a fact that the court repeatedly acknowledged. Gray made his public records request on a weekday during normal business hours at the address listed in the contract where public records are required to be stored. As is his custom, Gray video recorded his request so we know with certainty what actually happened. During the litigation, LSS made unsuccessful attempts to prohibit Gray from releasing the video. Gray spoke with the LSS representative listed in the contract as the contract manager, the person responsible for the administration of the contract, as well as the LSS representative who signed the contract. Gray asked to inspect and photograph records showing proof of liability insurance, a record that exists and something that would obviously be subject to disclosure. LSS refused, and Gray left empty-handed. Gray then filed suit to enforce the Public Records Act. The court's final order begins ominously as it contrasts Gray and LSS. Gray is described as someone who earns part of his livelihood by making public records requests for unwanted documents on unsuspecting private entities. LSS is described as a nonprofit corporation whose mission is to assist people in need, and it provides vitally important services to people in need within the community. The court's description of Gray makes him sound like a mercenary jackass, while its description of LSS makes it sound like something Mother Teresa could only have aspired to. Both are inaccurate. Gray, like every other person in Florida, has a constitutionally protected right to make a public records request, and LSS is being paid by the taxpayers of Florida to respect that right. And make no mistake, LSS is being paid. The contract states LSS shall allow public access to all public records. It is expressly understood that failure to comply with this provision shall constitute an immediate breach of contract for which the department may unilaterally terminate the contract. Aside from the court's troubling and obvious lack of impartiality, its conclusions are not based on facts or the law and stands in opposition to the decisions rendered by superior courts throughout Florida. The final order portrays Gray as an insincere man with entirely mercenary motives who spends his time making public records requests for records he neither wants nor needs. The LSS court opined that Gray preys upon unsuspecting and hapless government contractors, sometimes visiting more than one in a single day, and that Gray sets out to ambush government contractors using a baiting gesture. Although I do not believe any of those allegations to be true, the legal reality is that Gray's character and motivations are immaterial and beyond the ambit of any court's discretion. In 2002, the 4th DCA held in Curry v. State that the motivation of the person seeking the records does not impact the person's right to see them under the Public Records Act. Many other district courts of appeal have held equally blunt opinions regarding the motivation of a requester, describing it as immaterial and irrelevant. Another circuit court opinion, which was upheld on appeal, addressed the issue of motivation this way. The Florida Public Records Act makes no distinction between good and evil. The law provides any member of the public access to public records, whether he or she be the most outstanding civic citizen or the most heinous criminal. The court's final order held that Gray's failure to provide any advance notice justified the conduct of LSS. The Public Records Act is a well-developed area of the law with more than 500 appellate cases, some dating back to the 1890s, and not one discusses, much less supports, the proposition that a citizen must provide advance notice before making a public records request. The court held that LSS acted reasonably when it refused Gray's access to non-exempt public records because Gray failed to give written notice. Here, Florida courts have been exceedingly clear, with only very limited exceptions, none of which apply to the records Gray sought. The custodian of a public record is prohibited from conditioning access on a requirement that the citizen make his or her request in writing. In 2001, the 3rd DCA held in Dade Aviation Consultants versus Knight Ridder, Inc., that there is no requirement in the Public Records Act that requests for records be in writing. With stunning consistency, the appellate courts of Florida have been united on this issue. Without any evidence, and quite irresponsibly, the LSS court concluded that Gray and his attorney, Abraham Shockfay, engaged in fee splitting. The fact is, there have never been any attorney's fees for Shockfay to split with Gray because no fees have ever been awarded. It is true, in some cases, in addition to agreeing to take remedial action to prevent future violations of the Public Records Act, defendants have offered Gray a very modest monetary payment, usually not more than $2,500. And from those payments, Gray has had to cover the cost of filing fees, service of process, court reporters, and attorney's fees, which would have left him very little indeed. It is true also that the Public Records Act does not provide for monetary damages beyond reasonable attorney's fees and costs. The claim, therefore, is that since Gray was not entitled to any other monetary damages, any payment must have been for attorney's fees. And that is just silly. Prior to the resolution or adjudication of any case, no one is entitled to anything other than due process. So by definition, settlements involve the give and take of things to which no one is yet entitled. And according to the Florida Supreme Court, it is the policy of this state to encourage settlement of lawsuits. In fact, more than 98% of lawsuits are resolved through settlement, and without settlements, our judicial system would be paralyzed. Frankly, I think Gray deserves a lot of respect for always demanding that settlements include the government contractor's agreement to fix the problem, to comply with the terms of its contract, to respect the rights of citizens to know what their government is doing, and to obey the Public Records Act. The facts and the law in the LSS case are clear. Just as clear is that the court simply got it wrong. Thankfully, the appellate courts of Florida have consistently protected the rights of Floridians to know what their government is doing in their name and at their expense. And that's a right that does not depend upon the popularity of the requester or the charity of public officials.